Good morning, everyone. The meeting is called to order. Mr. Trillman, has anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
How are we today?
Very well, thanks.
Good. Let's see, one case to reconsider under agenda item 3.
Yes, sir. There is one case. Commission Appeals is requesting permission to resubmit wage claim case number 20-057991-7. This case was voted on docket 21 on May 24th, 2022. Case was pulled for additional discussion. And after discussion on the dais, the vote was incorrectly recorded as unanimous for all issues. Subsequently has been determined that clarification of the vote is needed. Therefore, Commission Appeals is requesting to resubmit the case on a future docket to clarify the vote. Commissioner Alvarez?
I agree to resubmit the case for future docket.
Commissioner Demerson?
Agree.
Mr. Chairman?
Agree.
Thank you.
Thank you. Let's move to tax liability cases under agenda item 4. I believe we have one tax case on docket 35, none on docket 36 or docket 37.
That is correct. The case on docket 35 is case number TD-22-019-0622. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
Thank you.
No for housing cases on agenda item 5.
Correct.
Under agenda item 6, we have no pulled wage claim cases on docket 35 or docket 36, but there are 2 cases on docket 37.
Yes, sir, that is correct. 2 cases on docket 37. The first is case number 21-051489-9. Commissioner Alvarez.
The decision is not supportable. This case was previously remanded to take additional testimony regarding good cause and the underlying merits. Although some testimony was taken regarding those issues at the January 6, 2022 hearing, none of that testimony was considered after a non-appearance at the continuance. The failure to consider that testimony was improper and not in compliance with the Texas payday rules. As such, the decision and subsequent decisions are void. Void February 11th, 2022, March 25th, 2022, and June 14th, 2022 decisions remand to the Wage Claim Appeal Tribunal to properly consider all evidence available on record.
The HE decision is supportable. After missing a remanded hearing, the claimant missed 2 additional hearings that were scheduled at her request. Her final Rule 16 request for a 4th hearing was filed over a month and a half late without any explanation as to why her appeal was late. The late request for another hearing means that the commission has no jurisdiction to rule on the merits of why she missed the prior hearing or of whether she is entitled to additional wages. Accordingly, we should affirm the AT decision. The claimant's Rule 16 request was late. The claimant did not have good cause for missing the 3 prior hearings, $884 of wages owed.
Affirm the AT5 untimely petition reopen. The AT4 decision remains in full force and effect.
Short form dissent.
Yes, sir. Thank you. And the second pulled case on docket 37 is case number 21-053354-0. Commissioner Alvarez.
The preliminary wage determination order was returned to the commission. After the claimant contacted TWC, a courtesy copy was emailed to her. In accordance with wage claim number 07-079750-0. The appeal timeframe does not begin merely because a party has constructive notice of a determination. There are no provisions in the act for TWC to issue a determination to a party through email. Since the claimant never received the determination, her appeal should be deemed timely and the case resubmitted. Reverse, deem timely, and resubmit.
The AT decision is supportable. After the original determination mailed to the claimant was returned as undeliverable and the claimant informed TWC that she had not received the ruling, TWC sent her another copy via email, which she received on the same day it was sent. Although she read the section regarding the 21-day appeal deadline, she elected not to file a timely appeal, but rather waited until she returned home to appeal. Long after her late appeal, she contacted TWC and was given arguably questionable information regarding her appeal rights. But that information, however questionable, did not cause her to file delayed appeal. Accordingly, we should affirm the AT decision. The claimant filed delayed appeal, no additional wages are due.
Reverse the AT, timely claimant appeal, resubmit.
Thank you. We will resubmit the case. So those were all the wage claim cases pulled for additional discussion. You should have received the wage claim short form dissent lists for dockets 35, 36, and 37.
Move we accept staff recommendations on remaining wage claim cases on dockets 35, 36, and 37.
I second the motion, except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 35, 36, and 37.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for dockets 35, 36, and 37.
Motion passes with the exceptions noted.
Thank you.
We will now move to agenda item 7, consideration of unemployment insurance cases on docket 35. Please proceed when you're ready.
Case number 272-7259, Commissioner Alvarez.
The AT decision should be reversed. The claimant signed a general release of claim with the employer in order to receive 8 weeks of payment. Under section 207.049B2 of the Act, a payment made pursuant to a written contract negotiated prior to the separation does not constitute disqualifying severance. The payment made to the claimant is not disqualifying since the claimant signed a general release of claim in order to receive it. Reverse the AT severance pay eligible. In the alternative, the period of disqualification should be modified. The claimant was entitled to 4 weeks of severance under an employer policy. Thus, the first 4 weeks for which was paid clearly did not constitute disqualifying severance. Modify the AT severance pay ineligible from 12/13/20 through 2/6/21.
The appeal tribunal decision should be affirmed. The claimant stated that she received the equivalent of 12 weeks of severance pay. The severance pay was not conditioned on any of the non-disqualifying factors found in 207.049B of the Act. As such, we should affirm the AT decision, severance disqualification from November 15th, 2020 through February 6th, 2021.
Reverse the AT, no severance disqualification, memo to investigate possible unreported earnings.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 292-6879, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I do not dispute the good cause issue. However, even if the employer did not have good cause for missing the hearing, the available evidence established that the claimant quit his job. In the absence of evidence that the claimant had good cause to quit, the employer's account should not be charged. We should modify the AT decision. The employer did not have good cause for its non-appearance, no chargeback.
The AT decision should be modified. Regarding good cause, the record reflects that the hearing officer made multiple attempts to contact the employer to participate in the AT1 hearing, but the employer never answered. At the AT2 hearing, the employer admitted that they have no excuse for having missed the AT1 hearing. Regarding chargeback, the record did not show the information sufficient to disturb the AT decision. Affirm the AT, no good cause, chargeback.
Modify the AT, employer did not establish good cause for AT1, no chargeback.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 296-5060, Commissioner Alvarez.
The decision is correct. The notice was sent to the employer on April 10th, 2020, and the employer has admitted to receiving it and reviewing it on April 14th, 2020. The employer did not provide a response until July 15th, 2021. More than 1 year past the deadline. The employer did not know why they waited so long to respond. A 14-month delay like this cannot be attributed to an onset of the pandemic. The response was simply late. Affirm the AT response to notice of maximum potential chargeback, not timely chargeback.
The AT decision is not supportable. This is another in a series of cases in which the employer was not told on the notice of maximum potential chargeback that it could have dealt with its claim volume problem by simply sending TWC a spreadsheet of all of the MPCs that it needed to protest. In addition, the dates in this case coincide with the height of the pandemic during the time frame in which claimants, employers, and TWCs were all overwhelmed by the volume of claims, appeals, and related proceedings. If the employer had the proper information, it could have responded to the chargeback notice on time. Regarding the chargeback issue, the testimony establishes that the claimant stopped making himself available for work assignments, even though continued work was available. Accordingly, we should reverse the AT decision. The employer filed a timely response to the chargeback notice and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3041564, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I do not dispute that the claimant filed a valid claim concerning the job separation in the home health care industry, and an employment relationship continues until one party clearly notifies the other party that the employment relationship is ended. Although the employer's policy required the claimant to contact the employer for additional work, she failed to contact the employer and thereafter filed her initial claim. Since the claimant severed the employment relationship by filing for unemployment benefits when continued work was in fact available, the claimant's separation constituted a voluntary quit without work-connected good cause. Hence, we should modify the AT decision, valid claim, voluntary leaving, no chargeback, and adequate employer response.
The AT decision should be affirmed. Regarding validity, the claimant filed a valid claim. Regarding the merits, the separation occurred when the employer removed the claimant from her assignment. It did not provide her with a new assignment, even though she was eligible for further work, as the employer testified. The claimant then filed the UI benefits and should be qualified. The employer's subsequent decision of a further assignment is irrelevant to this case. Affirm the AT, valid claim, no misconduct, chargeback.
Affirm the AT, valid claim, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Dimerson.
Case number 3062337, Commissioner Dimerson.
The AT decision is not supportable based on the evidence currently available. Although the employer consistently and credibly testified that the company filed a late protest to the NMPC due to non-receipt of the notice, the AT held that the employer's testimony was not consistent and credible because a witness testified that the company first became aware of the chargeback when it received the charge liability decision that was issued over 2 months after its late protest of the chargeback. Of course, that could not possibly have been true, but the AT clearly did not ask the logical follow-up question when it had the chance to do so. The proper follow-up question would have been, what prompted the company to file its protest on July 21st, 2021? Obviously, the witness misunderstood the hearing officer's question and was not given a chance to clear up the confusion. It's highly likely, based on countless other cases we've seen in this category, that the employer filed its late protest after receiving the 2021 tax rate notice that TWC sent in July 2021, which was months later than the agency usually sends tax rate notices. And once the company had researched the chargeback history underlying the tax rate, it discovered the chargeback. Proper questioning by the hearing officer could have revealed that I'm prepared to accept the employer's testimony of non-receipt as credible and consistent at this point, hold the protest timely, and have the case resubmitted on the merits of the chargeback issue. But if my fellow commissioners are not ready to do that, I would also be willing to hold a rehearing to allow the employer to explain why it filed its late protest when it did.
The AT decision should be affirmed. While the employer testified they did not receive the agency's May 29, 2020 notice, they also testified they became aware of the notice when they received the charge liability decision dated September 30th, 2021. But this testimony was not credible because the employer's late response was filed on July 21st, 2021, before the charge liability decision was sent, but still more than 1 year late. Affirm the AT, late response to notice, chargeback.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit the case.
Case number 3102652, Commissioner Alvarez.
The AT decision should be modified. The claimant became separated from employment when he was off of work for a week on a doctor's advice while recovering from a dental procedure. The claimant informed the plant manager of the condition, and he provided a copy of his doctor's note For the hearing, the claimant's absence due to a medically verified condition did not constitute misconduct connected with the work, and the employer's account should be protected from chargeback. Modify the AT, no misconduct chargeback due to MBI.
The appeal tribunal decision should be affirmed. The claimant quit his job without notice when he turned in his uniforms to the employer and left the premises. In addition, the claimant stated his plant manager made no mention of him violating any attendance policies for being out ill. Moreover, while the claimant had a medical note, he did not provide it to the employer. As such, the claimant's actions constituted a voluntary quit without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no charge.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3180247, Commissioner Alvarez.
The AT decision is not supportable. The claimant in this case had to sign a separation agreement in order to receive payment from the employer. The agreement the claimant signed included a general release of claims, a non-disparagement clause, and a confidentiality clause. The payments made to the claimant were consideration in exchange for the claimant's agreement to voluntarily relinquish substantial rights to the employer. Since the payments constituted consideration as part of such an agreement, they cannot constitute disqualifying severance pay. Reverse AT, severance pay eligible.
The appeal tribunal decision should be affirmed. The claimant received 9 weeks of severance pay. The severance pay was not conditioned on any of the non-disqualifying factors found in 207.049B of the Act. Accordingly, the claimant should be disqualified from benefits for the time period in question. We should therefore affirm the AT decision. Severance disqualification from March 20th, 2022 through May 21st, 2022.
Reverse the AT, no severance disqualification. Memo to investigate unreported earnings.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3199297, Commissioner Dimerson.
The AT decision is not supportable based on the existing record. The employer discharged the claimant for her record of poor work performance based upon her failure to follow up on certain tasks and specific instructions. The claimant partially explained her failure to set up meetings and new hire training by stating that certain company officials were unavailable to meet with her. The employer had one witness available at the hearing, but did not have the other person mentioned by the claimant available to testify. Since the employer could not have reasonably anticipated all of the company officials mentioned by the claimant, it should have an opportunity to respond to that testimony. Accordingly, we should hold a rehearing to allow the employer an opportunity to present firsthand testimony from the individuals specified by the claimant as having been involved in the events leading to her discharge.
The AT decision should be affirmed. The claimant was discharged for poor performance, and the employer testified that the claimant had never shown satisfactory job performance. The employer's testimony regarding the possible final incident was not clear, and it seemed to pertain to issues beyond the claimant's control. The employer did not produce any contemporaneous documents that reflect misconduct by the claimant. This employer has not demonstrated that the claimant committed any misconduct connected with the work. And our precedent holds that being discharged for failing to meet any employer's performance expectations is not considered misconduct. Affirm the AT, no misconduct chargeback.
Affirm the AT, no misconduct charge.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3214317, Commissioner Dimerson.
We should modify the appeal tribunal decision. The claimant was the only party to provide firsthand testimony about the job separation. She stated that the job separation occurred when she left work because she was experiencing symptoms consistent with COVID-19 and was subsequently advised by her doctor to quarantine for 2 weeks. While I recognize that the employer's testimony, which was based on secondhand accounts, may not best represent the events surrounding the final incident, this does not negate the fact that the job separation resulted from the claimant's absence due to COVID. As such, the claimant should be qualified for benefits and the employer's account should be protected from charge. We should therefore modify the AT decision, no misconduct, no chargeback, disaster. In the alternative, if my fellow commissioners do not agree, we should rehear this case for admission and review of the employer's documents, which were submitted prior to the hearing, but not received by the AT.
Mr. Miller, I would agree to Commissioner Demerson with the disaster.
Agreed.
We have a unanimous decision. Thank you.
Case number 3217110, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant has been counseled and instructed not to courtesy copy company emails to his personal email account. The claimant was aware that the employer's policy prohibited outside transmittal of confidential information. Despite this, the claimant continued to copy business emails to his personal email account, including health insurance and payroll information of multiple employees. The claimant's assertion that his actions were simply a mistake are neither credible nor persuasive. Because the claimant had been instructed to stop sending company emails to his personal account, and he continued to do this while on a final warning, the claimant mismanaged his position of employment. We should reverse the AT decision. Misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The employer discharged the claimant for an alleged policy violation regarding the claimant sending copies of emails from his work email address to his private email address. But the employer conceded that it had no specific policy against the practice, nor had it issued any warnings to the claimant against doing so. In addition, the employer stated that the claimant only engaged in the conduct after receiving a disciplinary action on an unrelated matter in April of 2022. But their evidence includes multiple instances of conduct having occurred prior to that date, none of which led to the warning or disciplinary action against the claimant. The employer's own evidence shows that the claimant was fired for reasons other than misconduct. Affirm the AT, no misconduct chargeback.
Affirm the 18, no misconduct chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson. And that was the last UI case pulled for additional discussion on docket 35. You should have received the UI short form dissent list for docket 35.
I move we accept staff recommendations on the remaining UI cases on docket 35, except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 35.
I second the motion except for those cases on which I'm dissenting as reflected on UI short form dissent list for docket 35.
I concur with the chairman's motion, except for the cases on which I am dissenting, as reflected in the UI short form dissent list for docket 35.
Motion passes with the exceptions noted.
Thank you. And proceeding to docket 36.
Case number 2843682, Commissioner Alvarez.
The AT decision in this case is incorrect. The separation in this case is based on a continued claim dated January 9th of 2021. The employer in this case is the same employer named on an initial claim and on a later continued claim dated January 30th of 2021. The claimant was on intermittent FMLA leave and partially unemployed individual. She was not completely separated from the employer until sometime after January 9th of 2021, when she then ran out of FMLA leave. There was no work separation that occurred in the claim week dated January 9th of 2021. Set aside the AT decision, void the separation determination, recompute the overpayment. Claimant was partially unemployed individual.
The appeal tribunal decision should be set aside. The claimant was neither totally nor partially unemployed at the time she filed her continued claim. As such, the claimant did not file a valid claim. Accordingly, we should set aside the AT decision and void the continued claim. Invalid claim, the claimant was not unemployed.
Set aside the AT, void the continued claim, invalid claim, not unemployed.
Short form and memo to UIA and OS to take a valid AC on the first claim week in which the claimant worked less than full-time hours.
Yes, sir. Thank you.
Thank you, Ms. Miller.
Case number 2867910, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I agree that the claimant did not have good cause for his non-appearance. Concerning the job separation, the record fully supports disqualification. The claimant was discharged after not meeting the employer's standards for safety and cleanliness in his department after multiple warnings, including a final warning. As a manager, the claimant was responsible for ensuring that the employer's protocols were followed. Less than 2 months after the claimant's final warning, the employer discovered additional safety violations in the claimant's department. In the absence of testimony from the claimant, the employer has met its burden of proving that the claimant was discharged for misconduct connected with the work. Finally, because the employer timely responded to the notice of claim, the AT should have included a chargeback ruling. Accordingly, we should modify the AT decision. The claimant did not have good cause for his non-appearance, misconduct, and add no chargeback ruling. Adequate employer response.
I agree that the claimant has not presented evidence to establish good cause to reopen the case. Regarding the available merits, the decision is not correct. The claimant was discharged for issues caused by other individuals. The record shows the claimant complained of these problems to the employer and was not aware that the employer found his work unsatisfactory. Evidence has not been presented to establish that the claimant had the supervisory authority to fix the issue himself. The employer has not provided evidence of misconduct. Modify the AT, no good cause, no misconduct, chargeback.
Modify the AT. Claimant did not establish good cause for AT1, misconduct, no chargeback, adequate employer respond.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2959867, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was discharged due to poor job performance. The employer stated that the claimant's job duties included talking to patients, collecting money, and scheduling appointments. The employer did not provide testimony that would indicate that these duties were highly technical or complex. Moreover, the employer stated that the claimant did not work to the best of her ability. As such, the employer has presented sufficient evidence to establish that the claimant's job performance was within her power to control, and the employer's account should not be charged. We should therefore reverse the appeal tribunal decision, no chargeback.
The decision is correct. The claimant was discharged for reasons other than misconduct connected with the work. As such, it is appropriate to charge the employer's account. Affirm the AT, chargeback.
Reverse the AT, no chargeback.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2964218, Commissioner Alvarez.
The decision is correct. The notice was sent electronically to the employer on April 13, 2020, and the employer opened the document on April 14, 2020. The employer did not provide a response until July 22nd, 2021, more than 1 year past the deadline. The employer did not know why they waited so long to respond. A 14-month delay like this cannot be attributed to the onset of the pandemic. The response was simply late. Affirm the AT, late responses to notice of maximum potential chargeback, chargeback.
The AT decision is not supportable. The original chargeback notice was mailed on April 13, 2020, during the period within which TWC employers and the claimants were overwhelmed by the volume of claims, and the U.S. Postal Service was having problems with shutdowns and mail delivery problems. In addition, the employer was short-staffed and was not informed that it could have dealt with its claim volume issues by including multiple chargeback protests in one letter. Under these circumstances, we should hold the employer's late protest timely. Regarding the merits of the chargeback issue, the employer's testimony shows that the claimant was a temporary employee who failed to report for reassignment after completing the last assignment with the client, as required by the employer's policy. Accordingly, we should reverse the AT decision. The employer filed a timely protest. The employer's account is not subject to chargeback.
Reverse the AT, timely response to the NNPC, no chargeback. Memo to investigate unreported earnings.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3081733, Commissioner Alvarez.
The AT decision on the separation is not supportable. The claimant was discharged when she failed to receive a COVID-19 vaccine after the employer implemented a COVID-19 vaccine requirement. The claimant applied for a medical exemption to the employer's mandate, but the employer did not respond to her request. On October 11, 2021, Governor Abbott issued Executive Order GA-40 that prohibited any employer in Texas from compelling the receipt of a COVID-19 vaccine by any employee who objects to such vaccination for any reason of personal conscience based on religious belief or for medical reasons. Moreover, on December 8, 2021, all three commissioners here today signed a letter to Texas employers reinforcing Governor Abbott's order. We wrote that it is unlikely that a claimant will be disqualified from receiving UI benefits if the separation was caused by the employee's failure to receive the COVID-19 vaccine. We also advise employers not to mandate a vaccine without notifying employees of the necessary exemptions and processes those exemptions in good faith. The claimant was discharged on October 24, 2021, after the governor's order was executed. Since the claimant was discharged due to COVID-19 vaccine requirement, she was discharged for reasons that were not misconduct connected with the work. Modify the AT, valid claim, no misconduct, bill reimbursing employer, void adequate response ruling.
We should affirm the AT decision. First, I do not contest the validity of claim issue. Concerning the job separation, prior to the governor's executive order in October on vaccines, the employer implemented a vaccination policy which required employees to submit a religious or medical exemption by September 3rd, 2021. The claimant quit without providing the employer with the requested medical exemption. As such, since the claimant failed to comply with the requisite policy in the allowed time frame, the claimant's separation arose from disqualifying circumstances. Hence, we should affirm the AT decision, valid initial claim, voluntary leaving, reimbursing employer not billed, sever the adequate response issue.
Modify the AT, valid claim, voluntary leaving, reimbursing employer not billed, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3110527, Commissioner Dimerson.
The appeal tribunal decision should be modified. The claimant was discharged due to behavior issues that were against the employer's policy. The claimant was told by his manager why a particular course of action could not be taken. In response, the claimant became argumentative and insisted that his way was the path to take. In addition, the employer's appeal indicates that this took place in front of his peers. Moreover, per the employer's response to the notice of application for benefits, the claimant had been put on a PIP by his previous manager for becoming argumentative and aggressive. As such, the claimant's behavior of insisting his way was best instead of adhering to his manager constituted work-connected misconduct. We should therefore modify the AT decision, misconduct, no chargeback, sever the adequate employer response.
The appeal tribunal decision should be reversed. The employer alleged that the claimant was discharged for violating their policies and insubordination. However, the employer has presented exclusively secondhand hearsay testimony, which is insufficient to overcome the claimant's sworn denial of the allegations. The claimant credibly testified that the supervisor was the aggressor in the final incident, not the claimant. The supervisor stood over the claimant who was seated and pointed her finger in his face. The claimant also credibly denied the other allegations from the employer. As such, the employer has presented insufficient evidence to prove that the claimant was discharged for misconduct connected with the work. Reverse the appeal tribunal decision. No misconduct, chargeback, void adequate response ruling.
Reverse the AT, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3169202, Commissioner Alvarez.
The AT decision should be modified. An agency determination established a continuing ineligibility due to the claimant's unavailability for work because her car needed repairs. While the claimant filed a late appeal to the determination on Monday, March 28, 2022, she testified that she was applying for jobs close to home and that she could still use her car to some extent. Additionally, agency records reflect that the claimant earned income during the week she filed the appeal. Clearly, the claimant is available for work, and the commission should take continuing jurisdiction and close the ineligibility. Modify the AT late appeal, claimant ineligible due to availability from February 13, 2022 through March 26, 2022.
We should affirm the AT decision. First, the record shows that the claimant did not file an appeal within the applicable appeal deadline. Hence, the claimant's appeal should be considered late. Concerning the availability issue, although the commission can assume continuing jurisdiction on the open period and eligibility as of March 14, 2022, the claimant testified that she lacked the requisite transportation, making her unavailable for work. Hence, the claimant's ineligibility should be left open until she informs the commission that she is available for full-time work. Affirm the AT decision, untimely claimant appeal, availability, not eligible beginning February 13, 2022.
Modify the AT, untimely claimant appeal, claimant not available for work February 13, 2022 through March 19th, 2022.
The closure dates between the chairman and you, Commissioner Alvarez, are not the same.
I would agree with the chairman.
Okay, thank you. The close is March 19th, 2022.
Yes, ma'am.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3172314, Commissioner Dimerson.
We should reverse the appeal tribunal decision on good cause. In appreciation of its employees, the owner decided to provide employees an extra day off on the Monday after Easter and close the office. This decision was unrelated to the appeal tribunal hearing, which was coincidentally scheduled for that same day. But when the employer's representative realized that there was a conflict, the representative reached out to the hearing officer, but did not get a call back. Because the employer's office was closed on the day of the hearing and the employer representative was not allowed to take records out of the office, the employer had established good cause for its non-appearance. We should reverse the AT decision. The employer had good cause for its non-appearance. Resubmit the case for merits testimony.
The appeal tribunal decision is correct. The employer's owner decided to close the office on the day of the hearing, even though he was aware of the scheduled hearing. There is no evidence that the employer was prevented from participating in the hearing due to circumstances beyond their control. The employer did not establish good cause for missing the hearing. On the separation issue, the claimant's last assignment ended because her client, her father, passed away. The claimant timely contacted the employer and requested a leave of absence to settle her father's affairs and attend his funeral. The employer approved her leave of absence. The employment relationship continued during her leave of absence because neither party took clear steps to end the employment relationship. Following the funeral, the claimant promptly reported that she was available for another assignment. After waiting 2 months for reassignment without an offer from the employer, the claimant filed for unemployment benefits. The claimant was clearly laid off due to a lack of work and separated for reasons other than misconduct connected with the work. Affirm the AT, no good cause for her non-appearance at AT1, no misconduct, chargeback.
Affirm the AT, employer failed to establish good cause for AT1, no misconduct, charge.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3191355, Commissioner Dimerson.
The commission should conduct a rehearing in this case. The employer provides multiple firsthand witness statements in its appeal to the commission. Since the witness statements provide firsthand accounts of the circumstances which led to the claimant's separation, we should conduct a rehearing to admit the employer's additional evidence and to take testimony from the employer's witnesses about the claimant's separation.
The AT decision should be affirmed. The claimant worked as the director for the employer's child care facility. The owner testified that she discharged the claimant over concerns about her performance, but that there was no final incident. The claimant was discharged in July of 2021, even though her last write-up occurred in early March 2021. The employer's own evidence establishes a clear record that the claimant was discharged at the convenience of the employer rather than any specific misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson. And that was the last UI case pulled for additional discussion on docket 36. You should receive the UI short form dissent list for docket 36.
I move we accept staff recommendations on the remaining UI cases on docket 36.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 36.
I encourage the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 36.
Motion passes with the exceptions noted.
Thank you. Proceeding to docket 37.
Case number 2909757, Commissioner Alvarez.
The AT decision should be modified. The claimant was not an employee of the named entity and was not at all times self-employed. As a self-employed individual, he is free to restart the work at any time. There has not been any work separation. Therefore, the separation ruling should be voided. Regarding the availability issue, the claimant lost the use of his personal vehicle transportation in January 2021. However, he testified that he applied for work in his local area. Further, the claimant lives in Houston, which has public transportation available. The claimant testimony as to when he lost his vehicle and when he obtained another one was somewhat confused and unclear. Nevertheless, his claim certifications clearly reflect a return to work and earnings again beginning in the claim week ending 3/20/2021. His appeal to the commission reflects that he was without transportation for about a month, which corroborates the earnings he reported. The preponderance of the evidence establishes that the claimant was without transportation until the benefit week ending 3/13/2021. The availability and ineligibility should be closed effective 3/13/2021. Void separation, claimant not available from January 24th, 2021 through March 13th, 2021, recompute overpayment.
We should modify the appeal tribunal decision. Concerning the job separation, the evidence shows that the claimant was unable to perform his primary job duty of food delivery when his vehicle broke down and he lacked transportation for work. Hence, the claimant did not establish good cause connected with the work for quitting. Concerning the availability issue, the claimant was unavailable for work from January 31st, 2021 and continuing until September 18th, 2021, because he lacked the requisite transportation for work. Therefore, we should modify the appeal tribunal decision, voluntary leaving, overpayment of $5,339, availability not eligible from January 31st, 2021 through September 18th, 2021.
Modify the AT, void the continued claim. Claimant's not available for work January 31, 2021 through March 13, 2021. Recalculate the overpayment.
Short form dissent.
Thank you, sir.
Thank you.
Before we move to the next case, you might want to check our availability dates between
Mhm.
Commissioner Alvarez and I.
Yes, sir. Okay, yeah, the start date is different.
Ms. Miller, to shorten time, I would agree with Chairman Daniel on
Thank you.
dates.
Okay. So that's January 24th. Could you please confirm your date, sir?
I have January 31st through March 13th.
January
of both
31st
2021.
through March 15th.
And I'm okay with that.
Thank you. Thank you, sir.
Case number 293-4263, Commissioner Alvarez.
The decision is not supportable. The claimant did not receive the hearing packet prior to the hearing because he was out of town tending to his ill parent. As such, the claimant was prevented from participating in the hearing due to circumstances beyond his control and has established good cause. Modify the AT, good cause, and resubmit. Even if the claimant did not have good cause, we should vote to rehear this case as the decision is not supported by the record. Prior to filing his initial claim with the effective date of 11/1/20, the claimant had ended his employment relationships with the employer and began performing services for the employer as an independent contractor. In accordance with the commission precedent, the separation at issue was his last work as an independent contractor before filing his initial claim. However, the first appeal tribunal decision ruled only on the separation when he transitioned from an employee to an independent contractor. This separation was only relevant to the issue of chargeback. As the nature of the independent contract, work is on a project basis or as needed basis. More information is needed regarding the claimant's services for the employer as an independent contractor prior to filing his initial claim. As such, we should rehear this case to determine the dates of the claimant's last work as an independent contractor prior to filing his initial claim and why those services ended. Additionally, a memo should be sent to the UIAOS department to contact the claimant to determine if the claimant had any subsequent separations from the employer after filing his initial claim and help the claimant file any necessary continued or additional claims.
We should modify the appeal tribunal decision. First, I do not contest that the claimant filed a valid claim. Concerning the good cause issue, the claimant was mailed the notice of hearing to his correct address of record. The evidence shows that the claimant went out of town and thereafter failed to make the requisite arrangements for receipt of mail. Since the claimant failed to provide credible and persuasive evidence that he was prevented from participating in the AT hearing due to circumstances beyond his control, the claimant did not establish good cause for missing the AT1 hearing. Concerning the job separation, the available evidence established that the claimant chose to end the employment relationship because he would earn more money as a contractor. Since the claimant initiated the job separation for personal reasons, the claimant quit without good cause connected with the work. Hence, we should modify the AT decision. The claimant did not have good cause for missing the AT1 hearing, valid initial claim, voluntary leaving, no chargeback, and sever the adequate response, employer response. And also a memo to UIA and OS to investigate the claimant's unreported earnings.
Reverse the AT, claimant established good cause for AT1, resubmit.
We will resubmit the case.
Case number 2947802, Commissioner Dimerson.
We should affirm the appeal tribunal decision. First, I agree that the claimant did not have good cause for her non-appearance. As to the job separation, the claimant was discharged after she made alarming and threatening comments to her coworkers. The claimant had received prior warnings regarding disrespectful and rude behavior and had been warned against any more outbursts of anger and hostility. In the absence of any controverting testimony from the claimant, in accordance with Commission Precedent, the employer has met its burden of proving that the claimant was discharged for misconduct connected with the work. We should affirm the AT decision. The claimant did not have good cause for her non-appearance misconduct.
The decision is correct. The claimant did not receive the notice of hearing prior to the hearing and was prevented from appearing due to circumstances beyond her control. The claimant has established good cause for missing the hearing, and the case should be resubmitted for merits. Reverse the AT, good cause, and resubmit. Alternatively, even if the claimant did not have good cause, the record establishes the claimant was discharged for reasons other than misconduct. The employer discharged the claimant for alleged statements she made to coworkers. The claimant denied making the statements at the time of her discharge and during her initial statements to the commission. The employer did not present witnesses of the final incident or the written statement from the claimant's coworkers they allegedly possess. There is insufficient evidence to establish misconduct. Modify the AT, no good cause, no misconduct.
Affirm the AT, claimant did not establish good cause for AT1, misconduct.
Short form dissent.
Thank you, Commissioner Alvarez.
Case number 2952498, Commissioner Alvarez.
The decision is not correct. The claimant did not receive a copy of the AT1 decision until the final day of the appeal period. The claimant submitted her appeal within a reasonable time of receiving the decision. Since the claimant did not receive the decision until the final day of the deadline and submitted her appeal within the reasonable time, her appeal should be deemed timely and the case resubmitted. Reverse the AT, deem timely, and resubmit.
The appeal tribunal decision should be affirmed. Although the claimant timely received the AT1 decision, she did not appeal the decision within the applicable time frame. Since the claimant's petition to reopen was not timely, we don't have jurisdiction to consider the underlying merits. As such, we should affirm the AT decision. The claimant filed a late petition to reopen, voluntary leaving.
Reverse the AT, timely petition to reopen, resubmit.
We will resubmit the case.
Case number 2984458, Commissioner Dimerson.
We should affirm the appeal tribunal decision. The claimant quit in anticipation of the employer's school district returning to face-to-face teaching at the beginning of the 2021-2022 school year. Although the claimant alleged health concerns for his inability to teach in person, the employer states that the claimant did not seek medical accommodations or mention his medical needs to the employer prior to his resignation. Since the claimant failed to provide the requisite medical documentation and thereafter quit months before the employer implemented the policy to return to in-person teaching, the claimant's separation constituted a voluntary quit without work-connected good cause. Hence, we should affirm the AT decision, voluntary leaving.
The decision is not correct. The claimant submitted a doctor's note from his employer to his employer indicating he needed to work remotely. The employer was able to accommodate the claimant's health restrictions until the end of the 2020-2021 school year. At the beginning of the summer break, the claimant's school principal informed the claimant that they would return to face-to-face learning for the following school year beginning in August. After learning the employer could no longer accommodate his health restrictions, the claimant submitted his resignation due to medically verified illness. Reverse the AT, no voluntary leaving.
Affirm the AT, voluntary leaving.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3071936, Commissioner Dimerson.
The appeal tribunal decision should be affirmed. The claimant has been placed on a performance improvement plan, a PIP, which cited time management as a top concern. In addition, file documents contain employee corrective action paperwork that note the claimant's job is in jeopardy. Nonetheless, the claimant was late to work on her final day with the employer. Transportation issues are the responsibility of the claimant, and her failure to correct those issues led to her trouble with attendance, which in turn contributed towards her poor job performance and ultimately culminated into termination. Because the claimant's PIP stated that failure to improve could lead to other disciplinary action up to and including termination, and because the PIP cited time management as a top priority, her failure to improve this aspect of her job constituted work-connected misconduct. We should therefore affirm the AT decision, misconduct, reimbursing employer not billed.
The decision is not correct. The employer specifically testified that the claimant was discharged for performance issues. However, the employer only provided vague testimony about the alleged performance issues and did not specify any final performance issue that led to the claimant's discharge. No evidence has been presented that the claimant ever met the employer's performance expectations or that she was not working to the best of her ability. There is also no evidence that the claimant accrued the required number of occurrences to be discharged under the attendance policy. As such, the employer has failed to provide that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, bill reimburse an employer's account.
Affirm the AT, misconduct, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3081362, Commissioner Dimerson.
We should reverse the appeal tribunal decision. Months before the governor's executive order, the employer required employees to certify certain information on health screenings to enter the employer's premises. If employees were not vaccinated or chose not to disclose their vaccination status, they were required to wear a mask at work. The claimant noted that he had been vaccinated on his health screening and did not wear a mask. However, when this status was questioned, the employer asked the claimant to provide proof of vaccination. Although this was a reasonable request from the employer and one that the claimant could have easily complied with, he refused. By refusing to comply with the reasonable employer request and by violating the employer's policy regarding cooperating with an investigation, the claimant mismanaged his position of employment. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer received a tip from a coworker that the claimant made anti-vaccination remarks and assumed that the claimant was lying on his daily health screenings regarding his vaccination status. The employer questioned the claimant about his vaccination status, and he reported that he was vaccinated. While the employer demanded that the claimant provide proof of his vaccination status, the employer had no policy requiring any employee to provide such proof. The claimant declined to share his private health information documents with the employer, as it was not required under the employer's policies. If the employer wanted to demand documentation of an employee's private health information, they should have placed a provision to do so in their policies. There is no evidence that the claimant ever agreed to voluntarily disclosing his private health information to the employer. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3131233, Commissioner Alvarez.
The AT decision should be modified. On the good cause issue, the claimant was not able to appear for the AT1 hearing because her attorney was unavailable for the hearing due to personal illness. This constitutes good cause for the non-appearance. On the separation, the claimant stated in her statement to the claims examiner that she was told that she was being let go because the company was downsizing. The employer responded to the notice of initial claim that the claimant was laid off. The employer admitted in its testimony that the claimant was not replaced because she was not needed. While the employer alleges that the claimant was discharged for attendance, there is no evidence of any prior warnings. However, supposed issues and the employer had with the claimant's attendance, the decision to separate the claimant was clearly based on the employer's business needs and not any misconduct. Modify the AT, good cause for the non-appearance. At AT1, no misconduct.
We should affirm the appeal tribunal decision. First, I do not contest the good cause issue. Concerning the job separation, the claimant was aware of the employer's policy, which required her to contact the employer in advance to report instances of tardiness or absences. Although the claimant was advised about the employer's policy on the day prior to her discharge, on that date of her separation, the claimant again violated the policy by arriving late without providing adequate notice. Since the claimant was aware of the employer's policy, but thereafter continued to violate the rule by reporting late without providing adequate notice, the claimant's conduct was mismanagement of her position of employment and was misconduct connected with the work. Hence, we should affirm the AT decision. The claimant had good cause for missing the AT1 hearing, misconduct.
Affirm the AT. Claim established good cause for AT1 misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3141918, Commissioner Dimerson.
The AT decision is not supportable. Past decisions of this commission have held that when claimants receive multiple determinations dated on or about the same day, their legitimate confusion over whether to file an appeal will excuse an otherwise late appeal that is filed within a reasonable amount of time after discovering the need to appeal. In this case, the employer had timely protested an earlier claim notice sent to it as the last employing unit. TWC determined that the claimant had named an incorrect LEU, last employing unit, and disallowed the claim, forcing the claimant to file a new corrected claim. That determination was mailed on the same day as the notice of maximum potential chargeback. The employer had legitimate confusion over whether it needed to file another protest so soon after the first one, especially since the claim voiding determination contains no information that would inform an employer, such as the one in this case, that a new claim would generate a new set of notices, requiring a new set of responses. So accordingly, we should hold the employer's late protest timely and have the case resubmitted on the merits of the chargeback issue.
The decision is correct. The employer testified they did not respond to the notice because they did not read the notice. Failure to read or understand a document has not been grounds for finding exceptions to the timeliness rules. Affirm the AT, response to notice of maximum potential chargeback, not timely chargeback.
Reverse the AT. Timely response to the NMPC. Resubmit.
We will resubmit the case.
Case number 3155476, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The employer discharged the claimant after he failed a post-accident drug test. In the absence of any denial from the claimant, the employer has met its burden of proving that the claimant was discharged for misconduct connected with the work. We should reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, if my fellow commissioners do not agree, we should grant a rehearing in this case. Under commission president, an employer is required to present documentation of 5 elements in order to establish misconduct in a drug testing case. Here, the employer was not provided notice of these 5 required elements. In the absence of such notice, the employer should not be penalized for failing to produce the required proof. As such, we should rehear this case and provide notice to the employer of the required documentation.
The decision is correct. The employer has provided conflicting testimony. The claimant was discharged for 2 no calls, no shows. The claimant was sent home and told not to report until the employer contacted him. The employer never contacted the claimant. The claimant failure to report to work was because he was following the employer's orders and the employer failed to notify him to return. Affirm the AT, no misconduct, chargeback.
Reverse the AT. Misconduct. No chargeback. Adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3179001, Commissioner Dimerson.
The commission should grant a rehearing in this case. The claimant was given a final warning for call avoidance. The employer stated that after it provided the final warning to the claimant, it discovered 10 additional calls that the claimant allegedly avoided. The It is unclear what exactly when those 10 additional calls took place, and clarity on this issue is critical since it could alter the outcome of the case. As such, we should conduct a rehearing for further development of the record on when the employer discovered the 10 additional calls, i.e. Whether the calls took place before or after the final warning, and for any recordings of the calls that the employer used as a basis for discharging the claimant.
The decision is correct. The employer discharged the claimant for call avoidance. The claimant had received a warning on January 11, 2022 for call avoidance. The employer then found other alleged incidents predating the warning and discharged the claimant. Although the employer later alleged the incidents might have occurred after the warning, the determination documentation only includes incidents predating the warning. The employer has failed to provide evidence of the claimant violating the employer's call avoidance policy after she received a warning. Since the claimant was discharged for incidents occurring prior to receiving a warning, she was discharged for reasons other than misconduct. Affirm the AT, no misconduct, chargeback.
Or the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 3189161, Commissioner Alvarez.
The decision is correct. The claimant worked for the employer as a part-time night shift caregiver. On April 25th, 2021, her assignment ended. The employer notified the claimant that they had no shifts to offer. As such, the employer was the first party to notify the other that the relationship had ended. The claimant was laid off when the employer informed her there was no shifts available. Affirm the AT, valid claim, no misconduct, chargeback.
The appeal tribunal decision should be reversed and decided under 207.045 of the Act. First, the claimant filed a valid claim. As to the job separation, the claimant quit when she did not respond to an offer of work from the employer, a home health agency. Per Commission President, in the home health referral industry, the working relationship continues until one party clearly notifies the other that the working relationship is ended. In the present case, the claimant clearly notified the employer that the working relationship had ended by not accepting the employer's offer of work. As such, the claimant quit without work-connected good cause. We should therefore reverse the AT decision, valid claim, voluntary leaving, no chargeback, adequate employer response.
Modify the AT, valid claim, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 3191682, Commissioner Alvarez.
Rather than testify herself, the claimant had her boyfriend testify on her behalf in the appeal tribunal hearing because she suffers from social anxiety. The hearing officer neglected to inform the claimant that the testimony from her boyfriend would be considered hearsay and therefore not given the same evidentiary weight as testimony from her directly. This case should be remanded to provide the claimant an informed opportunity to testify. Remand.
We should reverse the appeal tribunal decision. The claimant's fact-finding statements contains the most credible account of the events surrounding the claimant's separation. These establish that the claimant quit her job on the same day that she reported the issue to her supervisor. She further admitted that the communication from the employee and his family did not include threats of violence. Therefore, because the weight of the credible evidence established that the claimant quit without providing the employer an opportunity to address her concerns, the claimant quit without good cause connected with the work. We should reverse the AT decision, voluntary leaving, void the chargeback ruling.
Remand.
We will remand this case. And since this will result in a decision being mailed, did you want to short form dissent the remand?
Short form dissent.
We'll do that, sir.
Okay.
Mhm.
Case number 3228443, Commissioner Demerson.
The appeal tribunal decision should be reversed. First, the employer's protest to the notice of application for benefits should be deemed timely. As to the job separation, the employer testified that the claimant quit for personal reasons while continuing work was available. The employer also testified that the claimant's job was not in jeopardy. The claimant did not testify to the contrary since he did not appear for the hearing. As such, the claimant quit without work-connected good cause. We should therefore reverse the AT decision, timely employer protest, voluntary leaving, no chargeback, and adequate employer response. In the alternative, the commission should grant a rehearing in this case to further develop the record regarding whether the employer asked the claimant to report back for further assignment and to confront the employer with the claimant's fact-finding statements.
The AT decision should be reversed. I do not dispute that the employer's protest to the notice of initial claim should be considered timely because the employer did not receive the notice in its mail. On the separation, while the employer testified that the claimant quit, the claimant stated to the claims examiner that he had submitted his notice of resignation effective 12/31/20, which constituted a month of advance notice. The employer chose to accept his resignation, was accepted early on 12/16/2020 because the employer had no work available. Since the claimant gave more than 2 weeks' notice of the impending separation, the employer initiated the separation prior to the intended effective date because of lack of work. The claimant's separation should be characterized as a discharge due to a lack of work. The claimant was discharged for reasons other than misconduct connected with the work. Reverse AT, timely employer protest, no misconduct, chargeback.
Rehear.
We'll rehear the case.
Case number 3228564, Commissioner Alvarez.
The AT decision is not supportable. The claimant was absent from work for several days because she was severely ill. The claimant and her daughter provided very credible testimony that either the claimant or her daughter called the employer to report her absences on the day she missed work. On some days, the claimant's daughter called for her because the claimant could not breathe well enough to call in. The preponderance of the evidence establishes that the claimant kept the employer reasonably well informed of her status, and she was discharged due to her absences for personal illness. The claimant's separation was caused by her medical condition and was not for misconduct connected with the work. Reverse AT, no misconduct.
We should affirm the appeal to render decision. The claimant was discharged under the employer's policy after 3 days of no call, no show. The claimant was aware of the policy that required her to notify the employer each day that she was to be absent. The claimant had complied with this requirement by texting or emailing the employer for several days. Even if the claimant and her daughter had issues with reporting the claimant's absences via phone, the claimant could have continued to report her absences by text or email. Because the claimant was absent without notice for 3 days, the claimant mismanaged her position of employment. We should affirm the AT decision, misconduct.
Affirm the AT, misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez. And that was the last UI case pulled for additional discussion on docket 37. You should have received the short form dissent list for docket 37.
I move we accept staff recommendations on the remaining UI cases on docket 37, except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 37.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 37.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 37.
Motion passes with the exceptions.
Thank you very much.
Thank you. We'll take a short break.
Yes, sir.
This is agenda item 8, final rules for 40 Tech, chapter 809, childcare services.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Reagan Miller with the Child Care and Early Learning Division. Before you today are the final child care rules for adoption. These rule changes address several bills passed by the 87th Texas Legislature, including House Bill 2607, which makes Texas Rising Star certification mandatory for our child care services providers. House Bill 1792, which requires TWC to select a statewide entity for Texas Rising Star assessors, and Senate Bill 1555, which makes changes to the age reimbursement rates that we use. We began this process on December 21st with your approval of the policy concept, followed by your approval of the proposed rules for public comment on April 12th. The proposed rule amendments were published in the Texas Register on April 29th for the 30-day public comment period, which ended May 31st. We did receive comments from 19 entities, and the preamble notes where we have made changes in response to the comments received, which we did in about 10 cases. I'll highlight just a few of those. We did modify that during the up to 24-month entry-level period, providers can be assessed for Texas Rising Star certification at any time where they meet the eligibility screening requirements, not only after the first 12 months. Amending the rule for Texas Rising Star providers who were placed on suspension status to state that, well, they're still going to have their 6-month mandatory suspension period, but we did modify the overall time frame from a total of 12 to 15 months for them to achieve at least a 2-star rating. And we did retain the rule that states a provider cannot receive new referrals during the last 6 months of the suspension. We did add language to the rule to clarify that boards shall be responsible for Texas Rising Star assessor duties until the new centralized assessor entity is procured. And lastly, several rule amendments have a delayed effective date to coincide with the rollout of the agency's new child care case management system. This implementation date was adjusted from October 1st to December 1st of 2023. This modification still ensures that TWC is in alignment with Senate Bill 1555, which requires that TWC implement these new age range reimbursements no later than December 1st. And as part of these rule amendments, we also conducted the required 4-year rule review required under the government code and determined that the initial reasons for adopting the chapter still exist and that this chapter is still needed. Staff are recommending adoption of the final rule, and if adopted, requesting the ability to make minor non-substantive changes on the document in order to comply with the publication requirements of the Texas Register and the Office of Secretary of State. This concludes my remarks, and I'm happy to answer any questions.
Are there any comments or questions?
None here, Chairman.
None here.
Is there a motion?
I move that we approve and adopt the final rule amendments for chapter 809 childcare services.
Second.
It's been moved and seconded. Motion carries.
Thank you.
It's agenda item 9, final rules for 40 Tech, chapter 839, tax refund pilot program.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dennison, and Mr. Sarna. For the record, Carrie Ballas, Workforce Development Division. On July 5th, the Commission approved the proposed rules in TAC new Chapter 839 Apprenticeship Programs Additional. The proposed rules were published in the July 22nd issue of the Texas Register for a 30-day public comment period. No comments were received. Today's final rules are to implement Senate Bill 1524 from the 87th Texas Legislature, tax refund pilot program for certain persons who employ apprentices. Staff recommends adoption of the final rules to new 40 TAC Chapter 839. Should the Commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. I'm available if you have any questions.
Are there any comments or questions?
None here.
None here.
Is there a motion?
Chairman, I move that we approve and adopt final rules for chapter 839 tax refund pilot program for certain persons who employ apprentices.
Second.
It's been moved and seconded. Motion carries. This is agenda item 10, final rules for 40 Tech, chapter 839 Veterans Apprenticeship Training Program.
Good morning again. For the record, Carrie Ballast. On July 5th, the commission approved proposed rules for TAC New Chapter 839 Apprenticeship Programs Additional. The proposed rules were published in the Texas Register for a public comment period, and no comments were received. Today's final rules for Chapter 839 are to implement Senate Bill 337 of the 87th session, grants to facilitate participation in apprenticeship training programs by certain veterans and military personnel. Staff recommends adoption of the final rules to new 40 TAC Chapter 839. Should the commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. I'm available to answer any questions.
Any comments or questions?
Thank you, Carrie, for your work on the last two agenda items.
Thank you.
That's it.
None here.
Is there a motion?
Chairman, I move that we approve and adopt final rules for Chapter 839 grants to facilitate participation in registered apprenticeship programs by certain veterans and military personnel.
Awesome. Second.
It's been moved and seconded. Motion carries.
Thank you.
So agenda item 11, purchasing from people with disabilities program, central nonprofit agency management fee.
Good morning, Commissioners. Mr. Serna, Juan Garcia with the Voc Rehab Division. This morning for your consideration for approval are the proposed nonprofit agency management fee rates for FY 23, along with the method of calculation. Section 806.31 of the Texas Administrative Code requires the commission to approve both the management fee rates and the method of calculation on a yearly basis. The proposed rates and method of calculation are presented in the discussion paper before you. As required, the rates were posted for a 60-day public comment period. One comment was received and no changes are recommended based on this comment. Staff recommends the approval of the management fee rates and the method of calculation as presented in the discussion paper before you. With that, I can answer any questions you might have.
Comments or questions?
None here.
None.
Is there a motion?
Chairman, I move that we approve the central nonprofit agencies management fee for purchasing from Peoples with Disabilities State Use Program at 6% on the sales price for products, 6% on contract price for services, and 5% on contract price for temporary services, with the calculation method for management fee rates as presented by staff.
A second.
It's been moved and seconded. The motion carries. And item 12, recertification of community rehabilitation programs to participate in the PPD program.
Again, Commissioners, Juan Garcia with the Voc Rehab Division. Before you, for your consideration, are 6 CRPs or community rehab programs that are applying for recertification to continue participating in the Purchasing from People with Disabilities program. Details of each CRP are listed in the discussion paper before you. Section 806.41 of the Texas Administrative Code authorizes the commission to recertify a CRP every 3 years, provided that the requirements outlined in this section are met, Section 806.41. The applications of all 6 CRPs have been reviewed by staff and are deemed acceptable. Staff recommends the recertification of the 6 CRPs applying for recertification as presented in the discussion paper. With that, I can answer any questions you might have.
Any comments or questions?
Thank you, Mr. Garcia. None here.
None here.
Is there a motion?
I move that we approve recertification of the community rehabilitation programs to participate in the Purchasing from Peoples with Disabilities program as recommended by staff.
Second.
It's been moved and seconded. The motion carries. So agenda item 13, Rider 48 report, an inventory of apprenticeship and internship opportunities for people with disabilities. This report to the legislature and the Rehabilitation Council of Texas.
Hi, good morning. Good morning, Chairman Daniel, Commissioner Alvarez, and Commissioner Demerson. For the record, I'm Jamie Haywood with the Vocational Rehabilitation Division. This inventory is an inventory of apprenticeship and internship opportunities for individuals with disabilities. It is to be submitted to the legislature and the RCT by October the 1st of this year, as required by Rider 48 in the GAA of 22 and 23 by NEM. The inventory provides an overview of apprenticeship and internship opportunities, highlighting those funded by TWC And many of those opportunities we know are available to all job seekers, but this inventory also includes those available to individuals with disabilities. The inventory also describes opportunities that are funded specifically by TWC VR and are available to individuals with disabilities as requested in the inventory. And it also describes how TWC promotes both apprenticeship and internship opportunities, including funding for expansions, statewide conferences and events, and other outreach and awareness campaigns. And then finally, the inventory includes an appendix that lists apprenticeship and internship programs specifically available to cohorts of individuals with disabilities served in our VR program. Many of these opportunities are focused on preparing students with disabilities in high school for that successful transition to those post-secondary opportunities and employment. For following approval, TWC Design Services will complete the final layout and design of the inventory, and staff requests commission approval of this report along with the approval to make any necessary technical edits based on the final layout of the report. So with that, I'll be glad to answer any questions that you may have.
Any questions or comments?
Ms. Hayward, thank you for the presentation.
Thank
As
you.
you know, I'm very excited about what you all are doing with Explore Apprenticeship 2.0, and I want to thank Cheryl, Jason Baton, who's no longer in that department, but for him to take this task on. This was a great opportunity for those individuals or the people with a disability to explore what it's like or experience what it's like to be somewhat of as an apprentice. I had the opportunity to tour with some of the students that participated at the Port of Houston. The week before that, they were at NASA. So I just want to commend you all for this program. I look forward to reading the report.
This is Jamie's first time here.
It
This is
is.
Jamie's first time. Is Cheryl here today?
She is
No, I'm kidding. I saw her in the back there, but
my backup.
just in case. But I too, with Commissioner Alvarez, want to commend this report. I was excited about reading the report. The work that we're doing in the internship space is very important, and I'm looking at other ways that we can even add on to this. Commissioner Alvarez and Chairman, I know there's going to be a session in the Valley next week. We're doing Rally in the Valley where we're having an internship initiative and an apprenticeship conference followed on the days afterwards. And I can see us tying in folks with disability in this space in a big, big way. We have a couple of board members, governor appointees actually, that are heavy, Evelyn Cano and others that are heavy in the disability space in the Valley. And so we need to make sure that we're connecting the dots in the best way to bring about attention to these efforts. And I'm excited about the employers that are listed here as well. Those are employers that are making a difference in this space. And in this particular case, we're doing it with folks with disabilities. And so I look forward to working with you guys even more so with our Texas Interns Unite initiative, our Texas Internship Challenge initiative that we have here at the agency, and bringing attention to what these employers are doing for these employees here in our state with folks with disabilities. So thank you for the report and the work that's been done.
Thank you.
Well, I mean, normally when someone presents to the commission for the first time, I like to reward that with lots of in-depth questions that are often
I heard.
confusing and take us down so many different rabbit trails. But this is so well done, I can't even do that today. So I'm gonna save it for next time.
Nice.
Is there a motion?
I'd also like to add, Ms. Hayward, that if I'm not mistaken, this was approved by the past administration for allowing us to use pre-ETS funding. So we're the only state in the country, if I'm not mistaken, for being able to do this. So congratulations again to you and your team.
Thank you.
No further comments.
Is there a motion?
Chairman, I move that we approve the report of inventory of apprenticeship and internship opportunities for individuals with disabilities for submission to the Rehabilitation Council of Texas and the Texas Legislature.
But before I second, I want to give the chairman any other opportunity before Jamie leaves.
I'm saving it.
You say, okay, all right.
I've deferred that to the next time.
Next time, I'll go ahead and second the motion now.
All right, it's been moved and seconded. Motion carries. So agenda item 14, establishment of a blind premium payment for vocational rehabilitation employment service providers.
Good morning, Mr. Chairman, Commissioner Alvarez,
Mhm.
Commissioner Demerson, Mr. Sarna. For the record, Cheryl Fuller, Vocational Rehabilitation Division. Commissioners, before you today for consideration is a proposal to establish a premium payment for VR employment services providers who deliver services to participants who are blind or visually impaired. A disability-related premium payment is an additional payment on top of the standard rate for employment services paid to providers who have obtained and maintained a specialized skill set and credential that prepares them to deliver services to customers with a specific primary disability. We currently have these premium payments for qualified providers who serve customers who are deaf, those who have autism, and customers with brain injury. We are proposing the blind premium payment because blindness is a low incidence disability that requires customized and specialized knowledge and skills to ensure that services for customers with visual impairments are accessible and effective. Many providers lack this specialized knowledge and are therefore hesitant to serve VR customers who are blind, sometimes resulting in a delay in services to our customers because a qualified provider is not available. To qualify to receive this premium payment, staff proposes that interested providers must first complete online and in-person training and pass a certification assessment from the University of North Texas, the entity that administers the provider training, credentialing, and endorsement program for TWC VR. Providers who pass the certification assessment would obtain a credential that would qualify them for the premium payment when they complete employment services to a VR customer who is visually impaired. Staff recommends that the commission establish training requirements and an associated UNT credential for providers interested in obtaining the knowledge and skills necessary to deliver employment services to VR customers who are blind or visually impaired. Staff further recommends that the commission establish a blind premium payment of $12 per hour for individual services and a group rate of $6 per hour. That concludes my presentation, and I'm available to answer any questions you may have.
Any comments or questions?
Thank you for all you do, Cheryl, and your team.
None here. Thank you.
Is there a motion?
Chairman, I move that we establish a University of North Texas Workplace Inclusion and Sustainable Employment credential to serve blind and visually impaired VR customers and a blind premium payment of $12 per hour for individual service and a group rate of $6 per hour as recommended by staff and described in the discussion paper.
And before I second Cheryl, so this is autism first, hearing impaired second, and now we're going to those with blind. So
We have autism, individuals who are deaf or hard of hearing, and individuals who have brain injury,
Good,
and this
good.
will be the
I
fourth.
second the motion.
It's been moved to second, motion carries. This is agenda item 15, Special Administration Fund in connection with Lost Wages Assistant Program.
Good morning, Chairman, Commissioners. For the record, Mr. Senator Chris Nelson, Chief Financial Officer. TWC is scheduled to close out its grant with FEMA on the Lost Wages Assistance Program at the end of this month. For 6 benefit weeks during the COVID pandemic, August 1st, 2020 through September 5th, 2020, FEMA authorized an additional $300 for every payable claim while the Federal Pandemic Unemployment Compensation Program, or FPUC, was not authorized. TWC has paid out $2.95 billion in LWA payments, and of that has determined $4,184,400 are overpayments that should be returned to FEMA. During the closeout process with FEMA, they have notified TWC that all overpayments need to be remitted to FEMA, whether TWC has collected the overpayment from the claimant or not. With other federal unemployment insurance programs, TWC remits the overpayments to DOL as they collect the overpayments. Since TWC has no other source of funds to remit to FEMA at closeout, staff are asking the commission to consider the use of Labor Code 203.202, authorizing the Special Administration Fund to pay back the LWA overpayments to FEMA. TWC has issued letters to claimants identifying these LWA overpayments and requesting that the overpayment amounts be remitted to TWC. TWC has already started receiving some LWA overpayment checks. If approved, any LWA overpayments collected from the claimants will be deposited back into the Special Administration Fund. That concludes my comments, and I'd be happy to answer any questions.
Comments or questions?
None here, Chair.
None here.
About how many LWA payments total did we make?
It was 2.95 billion, Total.
2.59.
2.95 billion, almost just
95
short of 3
billion.
billion.
And then at this point in time, we have about $4 million in unrecovered overpayments.
That is correct.
What was the nature, typical nature of those overpayments? Do we break that out?
We can, the vast majority of it is unreported earnings. Claimants filed and didn't report their earnings correctly, and it went through a review process and was determined that they are in overpayment status.
And so we will we will square our account with FEMA and then continue our collection procedures on the remaining $4+ million.
This is correct. Now, after we have some special LWA admin funds available until closeout at the end of this month. If we wanted to continue collection activities after that, we would probably have to request additional Fund 165 using the same statute to authorize any additional collection activities.
All right, thank you. Is there a motion?
Yes, Chairman. I move that we authorize the use of $4,184,400 from a special administration fund to return to the lost wage assistance overpayments to FEMA until the funds can be recovered.
A second.
Yeah, it's been moved second. Both of the motion passes.
Thank you.
This is agenda item 16, local workforce development board child care targets for board contract year 2023.
Good morning again, Commissioners. Reagan Miller with the Child Care and Early Learning Division. This morning, Adam and I are presenting you with the board contract year 23 child care performance targets. The development of these targets is a joint effort between the Child Care and Early Learning Division and the Information, Innovation, and Insight Division. In developing these proposed targets, there were several program changes that needed to be considered. First, these targets reflect staff's recommendation to modify the base rates to the 75th percentile, and along with that, ensuring that the Texas Rising Star enhanced reimbursement rates comply with the state statutory requirements that they be at least 5%, 7%, and 9% higher than the base rate. And our calculations were based upon the most recent market rate survey. In this year's survey, we primarily saw increases in preschool and school age care. In no case are we recommending a decrease in the max rate below last year's level. I do want to note as a reminder that we do not pay more than a provider's published rate, which is the amount that they charge private pay parents. So even if the market rate went up, if the provider charges private pay parents less, we will only pay that published rate. The biggest change, of course, is House Bill 2607 and mandatory Texas Rising Star. As more providers increase their quality, they become eligible for that higher reimbursement rate. And as a result, our average cost of care goes up, which means we can serve fewer kids. So we ensure that these targets reflect our estimate of how much program growth we expect to see over the next few years. We're also proposing a mid-year review of these targets, which we generally don't formally do. But these targets are based on some assumptions. They're our best guesses of how program growth in particular will look. But if our assumptions are off and if the targets really aren't reflecting the reality of what's happening, they may need to be adjusted. In that case, of course, we would bring back a mid-year target adjustment for your consideration. So there's kind of the high-level program impacts, and I'll turn it over to Adam.
Good morning. We briefed your offices over the last few weeks into the specifics of the child care model, even though we had to make a lot of adjustments in the model in terms of implementing the changes that Reagan just talked about. The basic idea is still the same, which is that there's a fixed amount of money that's available to be used for admin ops, for direct care, and for quality purposes. We accounted for all of that in the model in terms of case mix changes, et cetera. And I'm happy to answer any questions you may have. It's about 140,000 kids per day for the next year. And of course, this is consistent with the LAR, where we built a model that would work for about that level of care for the next 3 years.
Any comments or questions?
None here, Chairman.
And I just continue to applaud the work that Reagan and the team are doing in the child care space. Continue to go out, and that issue continues to be one of a lot of concern. I like the fact that you're going to look at this 6 months down the line because of the assumptions and what we're doing here. So going in there, taking a look and adjusting is a good thing to do. So appreciate the work that's been done.
Is there a motion?
Chairman, I move that we approve the child care target setting methodology and assumptions to set the BCY 23 child care targets for local workforce development boards as presented by staff.
A second.
It's been moved to second, motion carries. This is agenda item 17, statewide initiatives. We'll start with a discussion paper on high demand job training in Texas Industry Partnership Program.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Cerna. For the record, I'm Christy Cavanis with the Outreach and Employer Initiatives Division. Can you hear me? Okay. Commissioners, on July 5th, 2022, Chairman Daniel requested staff to fully investigate the program performance of the high demand job training and the Texas Industry Partnership programs and the feasibility of combining these two programs into one line item, including establishing a supportable funding level. Staff reviewed both programs and considered prior feedback received from our community partners and local workforce development board applicants. Before you today for your consideration is a discussion paper related to those findings. By way of background, the high demand job training and Texas Industry Partnership programs were established to assist communities in supporting the needs of Texas employers by leveraging available state and local resources to promote training for high demand occupation. Local workforce development boards apply for the programs in coordination with economic development corporations, private corporations, or foundations to provide a one-to-one match of state workforce innovation and Opportunity Act funds. Staff has investigated the implications of combining the programs and have determined that alignment of the programs could help increase participation. This would involve aligning the program's parameters and allowable uses, making them as similar as possible with the exception of who is partnering financially. This could provide uniformity in the use of the funds and allow for more collaboration within the programs. Additionally, the commission could expand the entities eligible to provide a match under the TIP program. Staff has also determined it would be feasible to combine both programs into one budget item that could be shared by both programs. Based on anticipated increases in utilization, staff suggests allocating $2 million in WIOA funds to the combined budget. With commission approval, we would implement the outlined updates to both high demand job training and Texas Industry Partnerships as described in the discussion paper for FY 2023. Happy to answer any questions.
Any comments or questions?
I have a question. If approved, what is going to be the new name, or are we going to work on that? Since we're consolidating two programs.
We have not talked about a new name. We wanted to keep the spirit of the programs the same. So I would just assume we talk about them. It would have one application and then you would check the box whether it was high
Okay.
demand or TIP.
But-
So keep the names.
That's a really good question. And so for clarity, there won't be new names, right? The programs will continue to operate under their current name. They'll share a pool of funds and will align sort of the rules of the program. Rules is a wrong word. Our
That's the wrong word.
standing operating
Guidelines.
procedure on the
Guidelines.
programs.
Yes.
They'll be much more aligned where communities or applicants could use one or both and we would maximize the money in both programs. Am I
That is
understanding
exactly what
correct?
it is. We'd also have.
That's actually an excellent
Mhm.
question, but I don't think we're changing
Perfect.
anything, right? Okay,
No.
got it.
Well, I like the concept because it allows an entity or a municipality who didn't qualify for 4A, 4B can now be qualified for this, if I'm not mistaken.
Well, Commissioner, if I could, that unlocks dollars in communities that have already been collected from the taxpayers that sometimes we have a challenging time unlocking. The balance of 4A, 4B funds in communities, particularly rural communities and communities in the exurban areas, just in terms of using those for incentives or other things that the statute provides them to do, sometimes proves challenging and there's not a lot of continuity to this. Using this to unlock this for capacity building, training, and some other things that we can do really lets communities access a pool of money that they have available to them. They have to find certain ways to use that. Any other comments or questions?
None here.
Is there a motion?
Chairman, you want to make the motion?
I'm happy to. I move adoption of the recommendations laid out by staff in the discussion paper presented here today.
I'll second that.
Yes. Thanks.
Not done, Chrissy. He's already.
No, you have to let me, this happens every time, Christie.
I know. I'm sorry.
You have to let me say, it's been moved to second, the motion carries. Thank you so much for doing
Thank you.
that.
Move to second. All those in favor. We're all in favor of the motion.
I think so. Texas, the next one will be the Texas Industry Recognized Apprenticeship Grant Program.
Mr. Chairman, I'll bring that one to the commission, the attention. And so I have three WIO statewide commission reserve funding proposals that I handed out, I think about a month ago or so. And so I think you guys have had an opportunity to review this. But during the 86th regular Texas legislative session back in 2019, House Bill 2784 by the now Speaker of the House, Dade Phelan, who's a state representative at that time, created the Texas Industry Recognized Apprenticeship Grant Program. This grant program is intended to support certain apprenticeship programs that provide on-the-job training, preparatory instruction, supplementary instruction, or related instruction to an occupation that has been recognized as an apprenticeable occupation by DOL. Industry recognized apprenticeship programs, or IRAPs, are designed by third-party certifiers known as standard recognition entities, or SREs, and TWC was actually named an SRE back in September 2020. And so we've already had a statute has been passed. We've had the rulemaking approved by this commission body as well. And delighted to see that we also have an exceptional item that TWC will be pushing forward in the same vein. And so this initiative today that we're pushing forward is asking for $500,000 for 2 years, about $1 million totally from the WIOA statewide commission reserve. We also have a lot of industry support for this initiative. Industry support. We have Mike Maroney, who's visiting with us today. Mike, we appreciate your continued support of the efforts that we do from a workforce standpoint, economic development standpoint, plus some. So we continue to appreciate that. Also, those that were in favor of the bill were a number of industry organizations and associations that were out there, too many to name, but a lot of partners that continue to play a major role in our work. And so that's the initiative that we're pushing forward. If we are granted additional funding after the session through our exceptional item, then this is a program that will be able to go forward even more so from that standpoint. But this will allow us to stand something up, really look at the pros and cons and ways to operate it and the like. And therefore, I'm bringing this Texas Industry Recognized Apprenticeship Grant Program for initiative forward to work in collaboration with the House Bill 2784 that's already been passed. Any questions you guys might have?
Commissioner, I'd just like to thank you for this proposal that you've advanced. This certainly is a way to advance apprenticeship in Texas and thus improve the skills and wages of Texas workers. And so we were honored to be there at the signing at S&P Infrastructure a couple of years back, 2784. So congratulations. That's all I have.
So I have a comment and a question. Let me do it in reverse order. My question is are there any potentials for interference between the rules that are required of WIOA funds and anything that we might be doing relative to the IRAP program? Or should we be able to implement it as written, as it was passed in 2019? Well, and our rules, I guess, were passed in 2019, early 2020. Something.
Yeah, I don't see any implications at all. I've not been informed of any implications by staff on this initiative. I think we've pushed it forward as an exceptional item as well. And so things would happen after that point if approved. But currently, I don't see anything. I think it's been passed in statute. We've voted on the rulemaking part of it. And this is a funding mechanism to put in place what we've already approved.
Yeah. Let's place on the record that Courtney Arbor, director of the Workforce Division, went like this.
She went, Courtney went, no.
So I think that means
we're okay.
Everything you just said is 100% true, and she agrees with you. My comment is this: much like Commissioner Alvarez said, this gives us another tool that we can use to help get people into the workforce. We are seeing workforce shortages among many skilled trade positions. And trades you'd think of like plumbing, electricity, some healthcare professions, but I think you'll see across the manufacturing sector. I think you'll see a number of skilled trades positions that we're having a difficult time with our pipeline. It's two reasons. One's organic growth of the workforce in Texas, so that's a good problem to have. We're trying to keep up with the success of the employers that are operating in the state. And the second reason I think we're having this issue is just having enough training opportunities for people to upskill and reskill so that they can jump in and do this. we're seeing more advanced manufacturing added every day to the state's economy. And I can't say enough about all of our employers in the state in the skilled trades positions, whether those are high skills, middle skills, or even entry level positions where they're trying to get people trained and in here. The commitment of employers to either this industry recognized apprenticeship program or certainly the registered apprenticeship programs that have been championed for a long time here. You know, I'm just excited to the potential to have another tool in the toolbox. I am equally enthusiastic about working with the legislature through their process in terms of perhaps making or finding some passage for our exceptional item on the same exact topic for the same exact program. And I do envision if staff can stand this up fast enough, it would likely give us some talking points to the legislature when we arrive at that point in January. So I see a lot of synergy here. I see a lot of opportunities for us to do. This is not a pilot test. This is an implementation, but I think it'll act a little bit like a pilot test, given the small amount of money and it'll give us an idea of what to tell the legislature about our exceptional item request. So, is there a motion?
So I have one more comment,
Yes.
and I would like to add to what the chairman said regarding a great tool. I think when we heard this back when the signing, we thought this was a great tool, an additional tool that employers would have. And so we've been very fortunate. All three of us continue to promote the apprenticeship program throughout the state of Texas, which is a great program. My only concern here is as we continue to grow, we were at the campfire for Fort Worth with Reagan and her team, and Courtney was there as well, where we're expanding childcare developers or these programs where we're now producing educators. That's pretty impressive for the Texas Workforce Commission to do. We're leading the country in where we're at. If I'm not mistaken, we submitted some standards to Department of Labor, hopefully to get approval so that this healthcare professional or this healthcare nurse that we've been working on for some time now will be approved by the Department of Labor. We've had many discussions with them and we're hoping that this will soon come into fruition. Keep in mind that we have more non-union apprentices than we have union. And so we continue to grow in areas that didn't exist. For us to be able to talk about childcare or for us to even brag about the ability to produce brewmasters in South Texas is amazing what Texas is doing. And I have to compliment, you know, all the way from Courtney to, and of course, you know, we have folks here that are representing and of course, everyone that's been here making presentations. But I have to say that Desi Holmes and her team have done an amazing work on the expansion of apprenticeship. We're the only state that has received the expansion grant every round. And so my hat's off to her. We're probably the only state that has a conference that takes place yearly. And so I have to commend her and her team. The only request that I have here is that this funding that you're designating, because it's something new to the agency, that we allow some of that funding to create a new FTE designated specifically for that program.
Is there a motion?
Are you okay with that?
To create
Create an FTE that would oversee that program, because we're, you know, Desi's team is thinning out. We just have so much work for that team.
Let me just, as a point of clarification. So we can't create an FTE. We would have to ask Mr. Cerna to shift one from where it is now to somewhere else, or perhaps there's a vacancy. Mr. Cerna.
Based on commission feedback, we'll look to make sure that our apprenticeship team has got the right staffing level, which includes, if necessary, the addition of an FTE that's funded so that these funds are not affected out. The sense that I get is that the $500,000, we want to dedicate it into the program and not start pulling out administrative pieces, even if it's 60, 70, 80,000. So I guess a commitment that I'll make is that we'll preserve the funds if they're approved by the commission, the 1 million for the biennium for the 2 years, and find an FTE in the appropriate funding if necessary after we've done kind of a sort of an impact analysis of what the additional work will actually be. Because I agree with Commissioner Alvarez that team's doing a whole lot right now. They may be able to absorb a little bit more, but they may not. And I'd like the opportunity to look at that. But we can do that outside of this particular this particular agenda item.
Yeah, I think the amount is so small right now, $1 million is compared to what our exceptional item will be.
Right.
If we have the exceptional item, then I can definitely see where that would even be of interest even more so at that particular point as well. So Commissioner Alvarez, I agree with you that the need is there, and I look forward to our executive director working to make something like that happen. So,
I think the issue is we don't want to take people off of apprenticeship things that they're already
Right.
working on to work on this new thing. And we just want to make sure that it's adequately staffed.
We understand. I understand.
Well, we also want to make sure it's successful.
Yeah.
And so especially if we're asking that to be an exceptional item, I just want to be on the record that we're going to be strongly looking at creating or shifting or wherever the way you want to word it, that we get some assistance for that office.
I understand that. I understand that completely. As a
If
matter
it
of fact,
means that we
I
have to
recall-
add more money, we can do that.
As a matter of fact, if I recall, the exceptional items got an FTE or two associated with it
That's
already.
correct.
So
Okay. That's all I have, Chairman.
Or is there a motion?
Chairman, I move that we approve a Texas Industry Recognized Apprenticeship Grant Program in the amount of $500,000 for each of the 2 years from WIOA Statewide Commission Reserve and instruct the ED to set aside funds to create and explore a new FTE designated to administer this and other apprenticeship programs as otherwise described in this discussion paper.
second.
It's been moved and seconded. The motion carries.
Great.
This brings us to the Texas Employer Webinars, Virtual Employer Best Practices Training, Recruitment, Retention, Veterans, Foster Youth, and Disabled Workforce.
What a title.
It's a substantial title.
So this is an initiative, the past few years, of course, there have been challenges to employers and industry sectors on recruiting and retaining talent. So the proposal that I'm putting forward here are webinars to assist employers in enhancing their strategies for recruiting and retaining talent from certain populations. And so we want to look at people with disabilities, foster youth, and veterans. What quite often happens is that we assume that if we have an individual coming in with disabilities, or we assume that if a person is transitioning out of the foster youth area, or even our veterans, that a manager automatically knows how to manage or supervise that individual, and that is just not the case. And so this we're advocating a training of some sort where we'll be able to do webinars and bring in employer association, employer groups, and really work in tandem with whatever is out there to make sure that we are training up or giving opportunities and leaning in for folks in these areas, disabilities, foster youth, and veterans, and not assume that that's already a known factor when individuals are bringing that population out. And we're seeing a lot of even second chance could go into this area as well, that we really will assume that we know, but there are certain things, triggers, different things that one needs to know to assist in this area. And so this is a proposal to bring forward $30,000, $60,000 for the biennium to work with local organizations and groups to make that happen.
Comments or questions?
I don't have any comments.
None here. Is there a motion?
Commissioner Demerson, would you like to make the motion on this?
You make the motion.
You
and,
sure?
I'll second it.
Okay.
So I'm just pushing these forward.
I move that we set aside $30,000 for each year of the next biennium from the WIOA Statewide Commission Reserve to support 3 vital Texas employer webinars on best practices for recruitment and retention of veterans, transitioning foster youth, and the disabled workforce.
A second.
It's been moved and seconded. Motion carries. This is a proposal for Texas Interns Unite National Intern Day with a Texas Twist Annual Conference.
So, and let me thank both of you gentlemen for participating in our Texas Interns Unite National Intern Day that's always out there. But here in Texas, we do things different. And we did this with the Texas Twist Conference, and well-attended, good initiative. And so the funding that we've received through the Texas Interns Unite initiatives have come from the Texas Higher Education Coordinating Board, their GEAR funding. And we appreciate Commissioner Keller's work and his team's work with us in this initiative, in this internship initiative. What we're requesting here is $30,000, $60,000 per biennium, similar to what we've used this year for some of the initiatives. And this would be a number of sessions leading up to this annual conference. And so the $30,000 wouldn't be utilized for just one day, one conference. So it would be a number of initiatives rather, that are leading up to the annual conference that's going to take place in July, similar to some of the things that we're doing now, the Rally in the Valley that we're doing when Cheryl and Jamie were presenting on the internship opportunities in the disability space. My mind went immediately to us convening something dealing with interns and those that are disabled and the like. And so this allocation of funding would be utilized for initiatives as such, but all of that would be leading up to the July National Intern Day. But we'll do it with the Texas twist, and that's the initiatives. That's what's behind this proposal.
Comments or questions?
I wish that I had come up with the rally in the valley. God, I wish I had come up with that slogan. That was so cool, man. Love it. That's all I have.
Is there a motion?
Commissioner, you want me to make it? You want me?
Yes, yes.
Okay. I move we set aside 30,000 for each year of the next biennium from WIOA Statewide Commission Reserve to fund the Texas Interns Unite National Internship Day, Intern Day, with a Texas Twist annual conference to take place in July of 2023.
A second.
It's been moved and seconded and the motion carries. This is a discussion paper concerning esports as a STEM program.
Good morning, Chair Daniel, Commissioners, Mr. Cerna. For the record, Sandra Williams, Workforce Development Division. As requested by Commissioner Alvarez on August the 9th, staff have considered opportunities to support esports initiatives for Texas youth. Esports do provide a variety of education, of STEM education, including game design, competitive design, user interface design, computer hardware and network design, and synchronous computer operations. In addition, esports also provides many of the same benefits of traditional sports, including teamwork, commitment, leadership, responding to challenges, and self-confidence. Staff have identified 3 options that would allow TWC to increase opportunities for youth in regards to esports. The first is to create a competitive grant program to provide summer camps related to esports. The second is to create a competitive grant program to fund an after-school program related to esports. Both of these parameters are laid out in the discussion paper before you. The third is to add language to support existing summer STEM camps, the inclusion of esports, and to encourage those providers to provide those camps. Staff have identified $500,000 in Tanf statewide funding that's available to fund a program related to this decision. Staff seeks direction on making esport camps available to Texas youth with $500,000 in TANF statewide reserve. That's the end of my presentation, and I'm happy to answer any questions.
Comments or questions?
Chairman, I have a comment. Sandra, thank you for the presentation. I'd like to thank staff for putting together this discussion paper. Did a great job presenting the data behind electronic sports and why it is relevant to building pathways to STEM careers and is a gateway to college and universities. My preference would be to undertake the second option provided, award grants to ISDs and community-based organizations through the competitive process for hosting after-school programs for youth ages 14 to 21 to build esports skills. My only amendment to the second option is that I would like for charter schools to be able to participate in competitive grant process as well.
Other comments or questions?
I think the initiative brought forward. Thank you, Sandra, for bringing it. And Commissioner Alvarez, I think you proposed it originally or asked staff to look into this. I've gotten a lot of conversations with individuals about esports and the importance of it. I was in Arlington at our top meeting, the top meeting that was down there. And I walked in and it was a group of kids around, and I thought they were a soccer team, but they were an international team in our state, actually. Associated with the esports environment. And so they had their own team and the programs. It went way above what I could understand from that point, but it shows the importance of this area. I think they're even having an arena in Arlington that's an esports arena. And I know in Frisco, Texas, they're doing a lot of work in that space. And so thanks for bringing this initiative forward. It's going to allow us to do some things in that area. I'm interested in the data behind this. If there's anyone on staff, Commissioner Alvarez, if you have that, sharing that data on the importance of this industry would be pretty important, because we may be on to something here in Texas. So.
I'd also like to thank Chris Nelson, his wife asked me to be a commencement speaker. And this is where I first couple of years ago, I had an opportunity to kind of witness this for the first time and speak to some of the instructors that were actually involved in the training and the competitiveness of this and the value of having something like this. So I just wanted to take this opportunity to thank the high school for allowing me to be there.
What's the current balance of the Tanf statewide reserve?
I'd have to double check with Chris. However, I believe.
Will you let
it
him walk
is-
up here?
I would.
For the record, Chris Nelson, Chief Financial Officer. The current balance of TANF is statewide is 2.3 million. As we approved the budget, it was zero at that time. Since then, we've had some contracts close out with balances, so that's gone up to 2.3 million currently.
Let me say this about this particular discussion paper. I still maintain that we could probably do more as an agency with regard to youth programs. I think that we are still too piecemeal in the way we approach youth programs. STEM jobs are lucrative jobs. Those are good courses of study. And I think things that we can do in high school and even maybe 7th and 8th grade to put people on a path for a job in a STEM career, I do think is beneficial to the student. I think that TWC's approach has come together over the years, and I think we have some overlapping, and I'd love to see us make a serious effort at aligning these programs. I also don't think we spend enough money in this space. I don't really think we invest enough into training programs to advance youth in not just STEM careers, but a lot of different career paths that we know have a need for workers and that we know that there would be job opportunities for them. So I think, Commissioner Alvarez champions pre-apprenticeship, and I think sometimes we just hear pre-apprenticeship without understanding how we can really link together CTE courses, core academic courses, and put students who might not otherwise be on a path for the post-secondary training that they need on the right path. So, I mean, admittedly, I think we do some good. I just think that there's a lack of alignment among our own programs. And I don't think we probably deploy our money in the most efficient way to do that. So, I would be opposed to adding to that on those grounds, but I do see the merit in the esports arena. Colleges are adding this as a course of study. There are collegiate teams. I see why youth would be attracted to this. I see why they would participate in this. And I think exposure to those types of opportunities, particularly for youth who might not otherwise have had a chance to see that, I see the benefit in that. Of the three options, it happens the one I would have selected if it had been my decision alone would have been the second one. So I think Commissioner Alvarez and I are in agreement on that. I view this as a bit of a pilot project. But I will renew my request that we align these programs at a later date because I'd like to see us get all the youth programs on a similar page, make sure we've covered all the subject areas that we need to cover, and probably supplement that with available funds that we might have to do more training in the youth arena, because I just don't think we're getting everything done here. And I think this does a thing that's probably, it's certainly a valid thing, and I think it can be an important thing, but we're still not going far enough. That's not what you were asked to do. That's not really a commentary on your work here. It is very thorough. I did want to come back to something Commissioner Alvarez said. He wanted to include charter schools. He's absolutely right about that. And I think just for the future, when we talk about ISDs, my assumption is we're talking about charter schools as well. I guess we should probably enumerate that so that everybody understands that, but I think that's the page that we're on. So commissioners, certainly, however the commission responds to this today is how we move forward on this, but I will be bringing back up this topic of aligning youth programs, perhaps supplementing those youth programs with both additional programs and money, and looking at ways to make sure the youth programs are all working in conjunction with each other.
I appreciate that. Thank you very much for your presentation. I have in front of me how much we spend for youth WIOA, what our budget is, and I agree with the chairman. I mean, it's not even 10%, it's 5% of our budget, if I'm not mistaken, for the record, of our budget is used for youth programs. And so I just think that I agree that we need to spend a little bit more. I'm hoping that the tri-agency efforts will mimic some of the great things that are coming out of this agency as far as implementing some of these programs. So that's the only comments that I have to say, but I just wanted for the record to show how much of our budget is being used for youth initiatives from the agency.
All right, is there a motion?
Chairman, I move that we approve option 2 with the inclusion of charter schools and allocate 500,000 of TANF funding to support esports statewide initiative.
Second.
It's been moved and seconded. Motion carries.
Thank you.
This is the 2020 or a reentry conference for 2023. Let's say it like that.
I'm back. Good morning again, Commissioner Daniel, Commissioner Alvarez, Chairman Daniel, Commissioner Alvarez, and Commissioner Dimerson, and Mr. Serna. For the record, I'm Christy Cavanis with Outreach and Employer Initiatives Division. Commissioners, on August 9th, 2022, Commissioner Alvarez requested staff to draft a discussion paper to explore available funding to host a second reentry conference. Staff has reviewed the cost for the 22 Grace Conference, and from that developed a budget for a second event of $29,500 for roughly 200 people. By way of background, the Grace Conference was held in San Antonio on July 29th. The event was funded by a donation from the IKEA Foundation. 266 registered for the one-day event and approximately 145 people attended. The conference's purpose was to offer Texas employers an opportunity to learn how to increase their workforce while helping the formerly incarcerated individuals gain meaningful employment and the chance for a fresh start. TWC promoted the event to businesses around the state interested in developing a new talent pipeline with second chance individuals. In addition to the various speakers and panel discussions, there were also 10 booths featuring partnering organizations, and they were available to answer questions about working with this population. A second event could follow a similar format as the first one. However, since a funding source has not yet been identified, a savings could be realized by aligning the event with another TWC event, such as an annual conference. It's expected that by doing so, the agency would reduce the cost for the venue and related expenses by at least 1/3, with the total cost estimated between $15,000 and $20,000. Staff seeks commission direction on how to proceed regarding future reentry conferences and funding. This concludes my presentation, and I'm happy to answer any questions.
Any comments or questions?
Chairman, I do. I'd like to thank staff for looking into this. I am in support of hosting another conference. We can apply the IKEA balance to defray costs. I know there's a balance on that. I am not opposed to attaching this conference to another conference, although it would be my preference not to have it attached to the annual conference. The week of the annual conference is already busy, especially with conducting docket meeting on the site. I think it would be better served to attach the reentry conference to one of the other conferences, preferably one that already has a significant employer involvement. Since the reentry conference is geared towards informing employers of the opportunities available, if it were attached to a conference with heavy employer involvement, both would benefit. I believe the Apprenticeship Conference or one of the Texas Conference for Employers would be strong candidates. If we use the IKEA remaining balance, we are almost halfway to the amount proposed for the attached conference and would only need an additional $8,000. So I took consideration the recommendation that was made by our executive director. I took it seriously into consideration, but I think we're already overwhelmed with pre-conference events and with this docket that we're going to be having at site. So my prefer is to have the Texas Conference for Employers or another conference like the Apprenticeship Conference that we host.
So I tend to agree with you, Commissioner Alvarez, on the TCE conferences that we have that are coming out of our office, and well-attended conference. I think this last one, we had about 500 folks in San Marcos, 1,000 that were in the Woodlands, 800. They're sold out conferences of employers, and we wouldn't mind at all. I think it's an opportunity for us to bring even more employers to the table. So we're not opposed to working with the team to look at the TCEs that we have. And if there's a fit, there's a fit. If there's not, then you just tell us that we're going to do our conferences anyway. But if there's an opportunity for us to help in that regard, then we're open to doing that.
Is there a motion?
Yes, Chairman. And Chrissy, thank you for your work and your involvement at the conference and your team. Very well appreciated. I move that we fund a second entry conference utilizing the 7,000 IKEA balance and instruct staff to work with finance to identify the best funding source for the remaining 8,000 that would be needed to host a conference. Staff would also use their best judgment to determine if it is a standalone conference or attach it to another TWC event.
Second.
It's been moved and seconded. Motion carries.
Sir, just a little clarification. I understand the motion that was made and approved by the commission, but part of what staff's recommendation included was whether to charge a registration fee or not. In other words, whether to make it, there's no registration fee, but there's also no lunches. There was a lunch last time, or charge a registration fee that would cover the cost of a lunch and the cost of a standalone conference. Now, we would have to, considering that we would be pairing it with another conference, look through that. But, the cost would still be between 15 and 20, 29.5. So if we get a little bit of flexibility, if you don't mind, in coming back to the commission and say, okay, now that we've looked at it and we've identified these conferences to pair it with, not the annual conference. And just as a point of clarification, the docket and policy meeting at annual conference is only for this year. We don't have any plans for future years. But at any rate, we'd like the ability to be able to come back and say, these are the cost of pairing, and then get a decision from the commission concerning whether to charge or not.
I want to make sure the pairing that we're talking about, just want to be on record, we have our conferences already planned. And so the pairing would be asking staff to come find out what we're doing. And then
Yes,
if
sir.
there's something the next day or the evening of, but not interrupting our conferences as they exist at all.
That's part of what we need to do, is sit down and visit, for example, with your office, if that's those are the conferences that we want to consider pairing to, or if it's an apprenticeship conference or some other employer-centric conference that we're hosting. So yes, sir, that's part of it. Not to say we're taking over one of those, but rather here's how we would integrate a GRACE conference into that type of event.
Yeah, and I'm going to be careful with words. We're not going to place it within the TCEs, or so we're basically saying that we have a venue that's already existing. We already paid for it. If there's a cost benefit or an opportunity to bring that conference in, then you may do it on the third day. If we have a 1-day conference, you may do it the day after, or you may do it the evening of, but definitely not integrating that GRACE conference. I attended the GRACE conference, and it's not a mix in regards to what we do with our TCE conferences, but we will have a venue that's there. And if there's any cost savings to the agency by utilizing that venue or so, then take advantage of that. That's what we're offering.
That's part of what we want to analyze and be able to come back to the commission with.
Okay, thank you.
I would agree with you, Ed. I'm fine with that.
Did we announce the vote on?
Yes.
I think we did.
Mhm.
Motion carries. This is agenda item 20, board nomination.
Good morning, Courtney Arbor, Workforce Development Division. Today, for your consideration, we have workforce board nominations for Alamo, South Texas, Middle Rio Grande, Coastal Bend, and Southeast Texas. Staff recommends approval on the presented nominees as you've been briefed.
Comments or questions?
None here, Chairman.
None here.
Probably a good opportunity to act like this is Courtney's first.
I hadn't seen her in a while, so.
presentation. It's just
10
like,
years,
oh,
sir.
so-
10 years, no questions.
No, you're not taking any questions.
Mhm. Carrie, thank you for all your work. And your team, Carrie, Ballas, and everybody, just great, amazing work. So thank you for continued support. Apprenticeship.
Any additional comments or complicated questions?
No, I know Courtney well, so
Yeah, gotcha.
leave her
Is there a
alone.
motion?
Chairman, I move that we approve the board nominees for Alamo, South Texas, Middle Rio Grande, the Coastal Bend, and Southeast Texas.
Second.
It's been moved and seconded, and the motion carries.
Thank you.
Thank you. We could cue the walk-up music for the legislative report.
Right. We do have one.
That's disappointing. I thought you'd have that queued up.
Unfortunately, there were some issues securing the rights to it
Understood.
for broadcast.
Understood.
Good morning, Mr. Chairman, Commissioners, Mr. Cerna. For the record, Michael Brick, Governmental Relations. We'll be monitoring 2 congressional hearings this week. Tomorrow at 10 a.m., the U.S. House Education and Labor Committee will be holding a hearing regarding removing barriers to labor organization. And then on Thursday at 10 a.m., the U.S. House Small Business Subcommittee on Innovation, Entrepreneurship, and Workforce Development will hold a hearing on ways to support youth apprenticeship, entrepreneurship, and workforce development. This concludes my remarks. I'm happy to answer any questions.
Any questions?
Not here.
I'm here.
Thank you very much.
Thank you.
Mr. Sherman.
I have one item. Eric Holland will come up and provide some information concerning changes to the weekly unemployment insurance benefit amounts.
Good morning. For the record, Eric Holland, Deputy Director for Unemployment Insurance. I have an update relating to changes in the weekly unemployment insurance benefit amounts that will affect claimants that file new initial claims on or after October 2nd, 2022. This has no effect on existing claims. In accordance with Texas Labor Code, Chapter 207, the minimum and maximum weekly benefit amounts are established based on the Labor Market Information Department's analysis of Texas average weekly wage in covered employment for the preceding calendar year. LMI calculated that the average weekly wage in 2021 was $1,263.12, an increase of $60.41 or 5.0% over the preceding year. The minimum weekly unemployment benefit amount is set at 7.6% of Texas average weekly wage in covered employment. Furthermore, an increase to the minimum weekly benefit amount may not exceed $1 in any year. Last year, the minimum weekly benefit amount was established at $71. Therefore, this year, the minimum will be increased by $1 to $72. The maximum weekly benefit amount is set at 47.6% of Texas average weekly wage in covered employment. Furthermore, an increase to the maximum weekly benefit amount may not exceed $14 in any year. Last year, the maximum weekly benefit amount was established at $549. Therefore, this year, the maximum weekly benefit amount is at $563, an increase of $14. To summarize, effective with claims taken on or after October 2nd, 2022, the minimum unemployment weekly benefit amount will be $72 and the maximum will be $563. Again, this has no effect on existing claims. This concludes my update. I'm available for any questions.
Any comments or questions?
None here, Chairman.
Mr. Simon, my records indicate that this Eric's first time to present before the commission, at least in my recollection. He's denying it.
Yes, sir.
Mr. Simon, what are your records?
I believe that it's been long enough
No.
that this is considered his first time.
So what you're suggesting is any deference of questions he might have has evaporated.
It has.
It has. Right. I reserve my right to ask questions next time he makes an appearance here before. Any other questions for him?
Yeah, just want, Eric, that 563, when does that happen again? I missed that, so.
The new
Yeah.
minimum and maximum will begin with claims taken on or after October 2nd,
October 2nd.
2022.
Got it.
Yes, sir.
Thank you.
Anything else? Thank you. Is there any other order of business come forward?
Chairman, the only thing I'd like to add is conversations that we've had with other folks around the country. People are very interested in what Texas is doing to increase the number of apprentices. And so I want to applaud not only TWC, but its staff and the advancements we've made to encourage young individuals that there's another type of higher ed, and that is apprenticeship programs. We went from in 2016 to last in the number of apprentices to number 1 in the country. So I applaud again the folks that are involved in apprenticeship. And as stated earlier, sometimes there's confusion. As last week when I was in college, when people talk about pre-apprenticeship programs, CTE programs, internships, and apprenticeship programs, and now industry recognized apprenticeship programs, I think as a commission, we need to continue to market the various, the distinction between all 3 of them or all of them, because there is some confusion out there. And I will tell you that it gives me great pride whenever we go somewhere. I know we'll be going out of state again, and to tell everybody the accomplishments we've made, but it's all because of the directors that we have in here, everyone that's from childcare to our apprenticeship directors and everyone else. So I just wanted to take this opportunity to extend how appreciative that we are for the great work that they're doing, but we still have work to do when it comes to informing folks about the various types of education opportunities that are out there for them.
Chairman, I think we're all out there and you guys are out there, but I wanted to bring recognition to Commissioner Alvarez. I saw something when he was in Washington at the White House and being from Texas and representing Texas is a huge feat. And so congratulations on that effort as we continue to promote what Texas is doing and serving as an example to other states.
So I think most people in this room would agree that the future for this state looks very bright, but I would like everybody to write down in your day planner that September 7th, 2022, the state of Texas got brighter. So, we had 2 people in the office that were expecting a baby on or around the first part of September. Both those babies were born within hours of each other on September 7th. Moms are healthy, babies are healthy. One's boy, one's girl. And so we're looking forward to probably summer interns. I would bet by this next summer. That's what we're doing. Anyway, congratulations to Kim and Ren. And I know they're very happy about their growing families, and we are too. So thank you. Is there anything else?
Nothing here, Chairman.
Is there a motion to adjourn?
I move that we adjourn.
Second.
Been moved saying to adjourn, and we're adjourned. Thank you.